My Lord, thank you. Before I deal with the adequacy of the reopening jurisdiction, just a couple of points from the brief discussion we had before we broke. In answer to Lord Sales, one of Lord Sales's questions about what I would say about the appropriateness of the route that Mr. Trott decided to take, just probably more by way of interest than anything else. Under the Criminal Code Act 1907, and I was unaware of this, I've been educated over the short adjournment, Section 476G provides certain powers for a case management judge, and 476G2 provides that in a trial on indictment, the case management judge shall also have power to hear and decide any application pursuant to Section 15.1 of the second schedule to the Bermuda Constitution Order 1968, which directly relates to the trial. So I mention that just because it strikes me that that is a provision. It obviously wasn't raised in Trott, but that is a provision that it was enacted 6th of November 2015.
So does it say an application under Section 15.1?
Under Section 15.
So 15, would that be a constitutional motion?
It would be a constitutional motion. So this provision seems to be that making provision that an assigned case management judge in a criminal trial and indictment could in fact hear a constitutional motion if it directly relates to the trial.
Okay.
I don't say that alters the analysis I was putting forward this morning, but I mention it just.
But it should, I mean, at all events, whether you call it a constitutional motion or just an argument, this law does not apply.
Yes.
It suggests these things can, at least, even one can debate whether they should, but can be channeled through the criminal court.
Absolutely.
And the powers of the Court of Appeal are exactly the same as the powers of the First Instance Court?
Yes.
And what sections?
Section 17. Well, Section 17.1 is the of the. Let me find it, my lord. It's in the supplemental bundle. The Bermuda Court of Appeal Act starts at page 51 of the supplemental bundle, and the right of appeal is set out in Section 17, and I think it's Section 20 is the effect of giving. Section. I'm grateful. Yes, Section 8 deals with the powers of the Court of Appeal Act, so this is page 54. Shall have all the powers and duties conferred and imposed on the Supreme Court in the exercise of its original appellate jurisdiction. So it's 8.1. The second point, my Lord Stevens, I think the case that you were...
Right.
Indeed.
But more to the point, Lord Bingham's, the authority that Mr. Fitzgerald referred to, without citing it to us, was what?
I think he was referring to Hines, but I'll be coming.
No,
you're not.
Bow, the Bow.
Oh, Bow. But I think the same. Lord Bingham says.
Cited,
Lord Bingham says the same in Hines. And I'll be coming to it, my Lord.
Okay. Thank you very much indeed. Thank you.
And then the third point, just before going to adequacy, I was going to show you the affidavit of the DPP, which I alluded to. So it's page 47, 47 through to 50. And as I said earlier, the Miss Clark, DPP, obviously had access in making her affidavit to the audio recordings of the jury selection process that took place over the course of 2 days. She sets out in a lot of detail the process, and she explains at paragraph 4 that, top of page 48, the practice of the criminal courts was to have the prosecutor stand by those temporarily excused jurors if their excused period would fall within the expected length of trial. So in other words, the prosecutor knows that certain jurors have been temporarily excused, and the practice would be that they would then be stood by. The short point, and I don't intend to go through all of the detail, the short point is what she says at paragraph 21, which is page 50, which is that there was no potential juror that was stood by who was not eventually formally excused by the court.
So excuse is what? That they have prima facie good reason why
they should be allowed not to sit
absolutely, or they've been sort of excused because they couldn't sit for all, or they couldn't act as jury for all days during their period of when they've been a potential juror.
Right.
So in other words, the judge has excused all of the jurors that were stood by the Crown.
Okay.
You referred a moment ago, you drew a conclusion. You said all of them were excused, and where do we find that?
So that's paragraph 21, my Lord,
21.
page 50. So having explained the process, it's
Yes.
line 4. There was no potential juror stood by who was not eventually formally excused by the Crown. Therefore, it's by the court. Sorry, my Lord. Therefore, it's clear that none of the persons who would stood by would have been a member of the applicant's jury, and then.
And so sorry, how does that procedure work? So the Crown sort of just says this jurist step aside, and is there then some process after that where the court looks to see whether they have a good excuse or not?
If they can't fill sort of 12 seats, as it were, then jurors that have been stood by will be sort of effectively recalled as potential jurors. So it's a sort of filter. And
that happened here.
That happened here. And Miss Clark, I mean, it's paragraph 7, and the reason I didn't take the board to it is it is set out in a lot of detail, and it explains precisely what happened. So effectively, there were 6 jurors that were excused for knowing either a defendant or a witness. Then, in trying to fill the remaining 6 jury places, the Crown stood by 4 potential jurors. One of those was then excused because of his dates. One was excused because they were a client of the appellant's counsel. And then that process of effectively filling empty seats continues. And by the end, when you've got all 12 jurors, everyone that the Crown has exercised the right of standby has, for one reason or another, effectively been excused by the judge.
Not challenged for cause, but excused. Is that right? Excused
Yes.
on the basis
There were some words. Sorry.
Or on the basis that they knew people involved in the case, or whatever.
It's a combination. I think one was a client. Somebody knew one of the witnesses. Somebody's dates they weren't available for the entirety of the trial.
And in what sense, sorry to go on about this, but are they formally excused by the court, looking at paragraph 21? If they've been stood down by the prosecution...
Yeah, but then they come up again,
because
the standing down only puts them to the bottom of the list.
I see.
They're stood by,
okay.
but then there's a situation whereby those that are stood by, depending on how quickly you fill the remaining seats, could come back again.
So at that point, they really do have to justify them. The juror has to justify themselves to the court to say, I've got a good reason, why not? Okay, thank you.
Moving then to the question of whether an application to reopen is adequate means of redress. The board is obviously very familiar with now the Bermudan section 15.2. Just because I'll come to some of the authorities where we're looking at different jurisdictions, but just then to give the board a feel for similar constitutional provisions. So Bermuda section 15.2, you have the express provision that precludes the court granting constitutional relief if satisfied that adequate means of redress are otherwise available. The Bahamas and Barbados have identical constitutional provisions, and you have those in the bundle. It's section 28.2 in the Bahamas, which is page 730, and section 24.2 in Barbados, which is page 733. Grenada, section 16.2, there is no express provision precluding the court granting constitutional redress, but there is an express provision empowering the court to decline to grant constitutional relief if so satisfied, which is, I think, fairly unique to the Grenadian constitution. And then the board has seen some cases Mr. Fitzgerald has taken to Trinidad. It's section 14.2. There's no provision in Trinidad that precludes or empowers the court to decline constitutional redress, but there is a discretion. So that's the use of the word may. So there's a discretion built into the Trinidadian constitution. And if I can pick up our case at paragraph 21, which is page 265. We deal with the case of Farrington, which has been referred to, which is a judgment of my Lord Stevens, dealing with the identical provisions of Article 28.2 of the Bahamian Constitution, but they are identical to 15.2 of the Bermudan Constitution. That was I think what is said about Farrington by my learned friend is, well, it doesn't really offer much assistance, but if anything, I think he says, it shows that the board is willing to recast a constitutional appeal as an application to reopen an earlier appeal. And in my submission just on that point, I say that characterization of Farrington is wrong. That in Farrington, the board found that the Pinochet jurisdiction, so namely the inherent jurisdiction of the board in an appropriate case to rescind or vary its earlier advice, provided not only adequate but identical means of redress. And on that basis, under Article 28.2, held that the board could not grant constitutional redress. But what the board did not do in Farrington is recast the constitutional appeal as an application to reopen an earlier appeal. The appellant in Farrington had pursued to the board an application under the Pinochet jurisdiction in addition to his appeal from the dismissal of his constitutional motion. And we see that from the first paragraph of the judgment in Farrington, which is page 402.
Sorry,
402.
402.
And having found that the application to the board under the Pinochet jurisdiction provided adequate means of redress, the board was then effectively, as Lord Stevens says in his judgment, prevented from granting constitutional redress. Now the appellant, I think, says, well, on a pragmatic basis, what the board could do is recast the present constitutional motion as an application to reopen his criminal appeal. And we address in our written case, it's paragraphs 47 to 51, which starts at page 272, why the board should not accede to that plea. But if I can just sort of sum up what we say in our written case by making 2 points. First, I say it is not the function of an appellate court to recast the procedural route that a litigant has chosen to pursue in order effectively to overcome the gatekeeping requirement of section 15.2 of the Constitution. I say that this is a case where the appellant has chosen to adhere to an unsuitable and inappropriate route. And when one looks at the cases of Ramanoop and the case of Giroux, which is referred to in Ramanoop, they make it plain that that constitutes an abuse. I accept the learned friend's point in reliance on Ramanoop, which in Ramanoop it was said, well, if it becomes apparent that it is because there's a dispute of fact arises and it becomes apparent that it's not appropriate to continue with the constitutional motion, then you can effectively recast the constitutional motion as an ordinary writ. And that would be the appropriate way to then deal with the issue of fact. But that is not, in my submission, the case here.
But here he's got his appropriate route waiting for when this appeal is determined.
Well, first, yes, he has his appropriate route waiting for him, but also, even if there was any doubt in the appellant's mind about the appropriateness of reopening, as soon as the judgment in Roberts, as soon as he reads the judgment in Roberts, the Court of Appeal is saying in terms, the appropriate route to pursue in these circumstances is an application to reopen in your criminal appeal. So it is not on all fours at all with the facts of Ramanoop, and I do say it is in fact an abuse, to use the words of Giroux, to pursue a constitutional motion in those circumstances. And then the second point about why the board shouldn't recast the constitutional motion as an application to reopen is, well, the point my Lord Leggett has just put to me, the Court of Appeal is in fact seized of an application to reopen. So the appropriate thing, in my respectful submission for the board to do, would be to dismiss the appeal on the grounds that there are alternative adequate means of redress under 15.2, and then, as the Court of Appeal have said they would do, the Court of Appeal will then deal with the application to reopen that's in fact before it, but is effectively stayed pending the determination.
That was the timing point you made about December,
yes,
whatever it was,
yes,
the correspondence back
yes,
from the Court of Appeal.
Yes,
okay.
my lord. Briefly, if I can just turn to the authorities, and I think there isn't an issue between my learned friend, because there is a very well-established line of authorities, starting really with Maharaj number 2, then Chocolingo, then Hines, and then Ramanoop, that supports the proposition that the constitutional route must not be used to mount a collateral attack on a judicial decision that could and should have been challenged on appeal, and to do so is an abuse. And we deal with these cases, it's paragraph 22 of our written case, which is page 266. I don't intend to take the board to the first of those two cases I mentioned, Maharaj or Chocolingo, because they are both cited and dealt with in Hines. So if I could just ask the board to turn up Hines, which is page 357. And Hines was an appeal from Barbados, Barbados containing an identical provision to section 15.2. And having unsuccessfully appealed his conviction to the Court of Appeal, this was a denial of legal representation point. So it was said that a denial of legal representation infringed his constitutional rights. The appellant then applied for constitutional redress under the Barbadian equivalent sections, which is section Article 24.1. And the judge in the Court of Appeal dismissed that application on the basis that adequate means of redress had been available to the appellant. If I can ask the board to pick it up at page 371, please. And it's really paragraphs 20 through to 24. And I obviously am not going to read them, but you'll see referenced in para 23 to the Maharaj case, that's judgment of Lord Diplock, and then over the page, another judgment of Lord Diplock in a slightly later case, Chocolingo. And then at paragraph 24, having cited those cases, Lord Bingham says, on the facts of this case, there is, in the opinion of the board, no answer to Mr. Guthrie's submissions. It would be undesirable to stifle or inhibit the grant of constitutional relief in cases where a claim to such relief is established and such relief is unavailable or is not readily available through the ordinary avenue of appeal. As it's a living instrument, so must the Constitution be an effective instrument. But Lord Diplock's salutary warning remains pertinent. A claim for constitutional relief does not ordinarily offer an alternative means of challenging a conviction or a judicial decision, nor an additional means where such a challenge based on constitutional grounds has been made and rejected. So I submit that is respectfully, that's the correct starting point. You then, next in the series of cases, have Ramanoop, and perhaps in light of my learned friend's reliance on Ramanoop, I just need to take you briefly to it. It's at page 33, I think it's at 338. We're now in Trinidad, so Trinidad does not have a preclusionary provision, but it has the discretionary provision in the Constitution about constitutional relief. This concerned an application for constitutional relief following an assault by a police constable during an arrest, and it was the Attorney General's appeal. And if I can pick it up at paragraph 23, which is 347, judgment of Lord Nichols. Paragraph 23, dealing with a case called Harricassoon. Over the page, or perhaps just looking at paragraph 25, where he says, in other words, where there is a parallel remedy, constitutional relief should not be sought unless the circumstance of which complaint is made includes some feature which makes it appropriate to take that course. as a general rule, there must be some feature which at least arguably indicates that means of legal redress otherwise available would not be adequate. Then you see at paragraph 27 Chocolingo being cited. And then, if I can, over the page, pick it up at 31, where Lord Nichols says, the observations in Giroux's case are not to be taken as differing from what's set out above. In Giroux's case, Lord Hope said this, if, as in the case, it becomes clear after the motion has been filed that the use of the originating motion procedure is no longer appropriate, steps should be taken without delay to withdraw the motion from the High Court, as its continued use in such circumstances will be an abuse. Lord Hope's observation was directed to the case where proceedings seeking constitutional redress are properly started, and it later becomes apparent that the parallel remedy is the appropriate remedy. And then skipping to the bottom of the page, instead he chose to adhere to what has become an unsuitable and inappropriate procedure. It was in this circumstance that the board agreed with the Court of Appeal that the applicant proceeded as he did was an abuse of process. And so I do say that you have the starting point that is, if your means of redress should be through the criminal appeal route, not a constitutional motion, and then you have the observations there of Lord Nichols, but also Lord Hope, and this isn't a case that anything has changed, such that the board should treat this as effectively a reopening application. This is, I say, a clear case of abuse. The appellant, certainly by the time Roberts has been delivered, knew what his correct avenue of redress was, and yet he's continued to pursue a constitutional motion. Turning then to the appellant's, addressing the appellant's arguments as to why they say reopening is not adequate. In their written case, they set out 6 arguments, and we've responded to those in writing, paragraphs 28 to 58 of our written case, which starts at page 268. I don't propose, because my learned friend has not developed all of those 6 arguments orally, but I obviously don't understand him to be abandoning any of those points, but I'll leave those that he hasn't addressed orally to be addressed in writing, and you have our responses in our written case. I do, though...
Sorry, you did give us the paragraph numbers.
It's paragraphs 28 through to 58, my lord.
Thank you.
Starting at page 268.
Yep.
I just want to focus, I think, on 3, though, that my learned friend has expanded on orally. And the first argument is that it was by no means clear that there was an alternative remedy when the appellant filed his constitutional motion. And as we make the point of paragraph 30 of our written case, obviously section 15.2 doesn't require the means of redress to be, as we put it, formally recognised in some prior judicial authority at the time of filing. But in any event, and this is the point I've just made a moment ago, by the time you get to Roberts, there was then, prior to the time you get to Roberts, there is highly persuasive authority from this jurisdiction in the case of Yassain. That was a judgment that was handed down in July 2015, and that is, your lordships will recall, that's the case that confirmed that the Taylor and Lawrence jurisdiction in civil proceedings applied in criminal proceedings. So there is no reason to doubt that the reasoning in Yassain would not apply with equal force in Bermuda. And in fact, when one reads the judgment in Roberts, that's precisely the conclusion that the Court of Appeal come to, and they apply the reasoning in Yassain to find that they have the implied power to reopen in exceptional cases.
So far as the appellant is seeking to argue that the way in which the test was interpreted in this context in Roberts as requiring actual bias that would probably have affected or altered the result, how could that argument be raised procedurally?
It could only be raised in the Privy Council. The Court of Appeal would be bound by its own decision, and you'd have to appeal the refusal of the Court of Appeal to reopen its decision to the Privy Council. You'd be back here again.
Yes, my lord. Yes, if the objection is to the test that's been set down in
well, I mean that's a substantial part of the argument.
Yes. Yes, I would accept that. But that, and I will of course deal with, and this is a separate point, the inadequacy point being that the test in Roberts itself is, and I will obviously deal with that.
Yes.
Just dealing with.
I was just trying to think, if we think that there's, some mileage in that argument, I'm just wondering how it should have been raised on your approach. I don't know if you can appeal to the Privy Council a refusal to reopen a case. You probably can't.
My lord, I probably don't want to. I probably don't want to be drawn into that discussion. But I don't, as a matter of.
No appeal from the Court of Appeal.
No, quite.
I'm not sure. I think there isn't. I think your lordships don't. I think obviously have to determine this, but I think there would be an argument as to the ability to appeal a refusal to reopen the Court of Appeal to the board.
I mean, that's not possible so far as the Court of Appeal and the Supreme Court is concerned. That's right. Certainly not in civil proceedings.
No.
No, but we're more generous in our
yes,
appeal rights to.
Yes, well, yes.
I think the way the argument would go is that obviously appeals to the board are governed by the Appeals Act 1911. I think a refusal by the Court of Appeal to reopen would constitute a judgment of the court for the purposes of Section 2C of the 1911 Act. And then an appeal would lie to the board, obviously at the discretion of the Court of Appeal, if, in the opinion of the Court of Appeal, the question involved in that appeal was a question of great general or public importance. So I'm thinking on my feet, I don't see why, as a matter of principle, it wouldn't be possible, but you would have to satisfy the Court of Appeal that it was a matter of great general or public importance.
Well, they were persuaded in this case that it was, presumably, were they? I mean, on this appeal.
Well, I think on this appeal it's actually different because there's just a right to appeal to the board because it's a constitutional motion. You have an appeal as of right.
Oh, I see.
Albeit the Court of Appeal, yes, the way it procedurally works is you do still go through the motions, as it were, of asking for permission. And in fact, in this case, the Court of Appeal gave us a reasoned judgment as to why they thought permission should be granted. But there is an appeal as of right.
Right.
Subject to there being a genuinely disputable issue.
Yes.
And that's what they looked at.
Yes, absolutely, my lord. Yes, that's right. So that first point really goes to the argument. Well, it being said by the appellant, well, I didn't know that I didn't even know that I could apply to reopen, and that's why that remedy is inadequate. And I say there isn't, with respect, any real mileage in that. Secondly, it is said, and this is the procedural point my learned friend dealt with this morning, it's just not well established in Bermuda, and it's not subject to clear rules. And we deal with this at paras 32 to 37 of our written case. And I think I can distill what we say there into four, hopefully fairly short points, but also deal with the Berry point, probably at this point as well. The first thing we would say is, well, the jurisdiction governing reopening criminal appeals may still be developing in Bermuda, but the Court of Appeal in Roberts has obviously recognised and exercised such a power, so it's a matter of substance, not form, that such a mechanism exists. And to sort of expand on what I said sort of on instructions earlier, because the point is obviously taken by my little friend, well, and I don't accept this as a proposition, but I think it is said, unless I have the right to a hearing, then that means that the means of redress are not adequate. Now, as a proposition, I don't accept that. I say there's no reason why you can't have a filter that precludes you from having a hearing. But in actual fact, the reality is, in Bermuda, and it's, I can obviously provide copies to the board. Attached to the rules of the Court of Appeal of Bermuda are criminal forms, and criminal form 8 is a form that is entitled Notification to Appellant of a Single Judge's Decision. So that is the notification that you would get if you made an application for an extension of time within which to file a notice of appeal or an application for leave to appeal. A reopening application would be treated as an application to extend time, and you will in fact perhaps recall when we looked at the appellant's application, it was an application to extend time, so he's not referring to it as a reopening application, but that, I say that difference in language matters not. So that is the notification, and then criminal form 9 is entitled Notice of Appeal by Appellant from Refusal of a Single Judge. And this is the form that you would complete if you have been refused by a single judge. It says on form 8, if you desire to have the above-mentioned application which have been refused determined by the full court, you are required to fill an enclosed criminal form 9. And then criminal form 9 says, I've received your notification that my application is for leave to appeal or an extension of time, and hereby I give you notice that I desire this to be heard by the full court.
I mean, since this has been raised, I think it would be helpful if you
Of course, I can provide. So it's the rules of the Court of Appeal of Bermuda, and this is, I think, annexes to it. But I will, of course, provide that. It is, though, fair to say, that certainly as far as the DPP is concerned, there have been no applications, sort of renewed applications for a sort of oral hearing following a refusal of an application to reopen in Bermuda. And it may be that's because this is developing jurisprudence. But so that is the mechanism. But as far as we're aware, I can't point to an instance of someone through Form 9 inviting the Court of Appeal to, as a full court to hear a renewal application effectively.
And so just to check, is this right, that you say that there's nothing in paragraph 73 of the Court of Appeal in Roberts, page 482, which is purporting to lay down some separate procedure? It's assuming that it's the ordinary procedure that applies. Yes,
my Lord, I do say that. On this same, I said that just four very brief points on this argument about the power to reopen not being well established. That's really the procedural point. I think the appellant certainly says in their written case, well, the reopening jurisdiction should be confined to procedural errors. I say, well, that slightly misstates the position as it's developed in this jurisdiction. I accept entirely what Mr. Fitzgerald rightly said about originally Majeski and cases like Majeski and Daniel were dealing with instances where there has been effectively a nullity. But the law has moved on, and there's a more recent case called Zuman and Khan, which is at page 1878, which is a Court of Appeal decision from this jurisdiction, Lord Justice Stuart Smith, at paragraph 70 to 72, confirming that the jurisdiction is not rigorously confined to cases involving procedural errors, but is likely to be confined to exceptional circumstances when the lack of an effective alternative remedy would or might otherwise lead to manifest injustice. So yes, the threshold is high, I say rightly so in closed cases because of the principle of finality and the importance of the principle of finality, but the jurisdiction is not confined to cases of nullity or procedural error. I think it's said by the appellant that also it's not even clear in the change of law case whether it would be appropriate to apply to reopen. That might be right in this jurisdiction because of the Criminal Cases Review Commission. Bermuda's legal system does not have a CCRC-style body, but that is not an answer to whether there's an adequate remedy. That is, if you like, a peculiarity of this system, that if there is a change of law case, you would go through the route of going to the CCRC. And I suppose I come back to the point, which is that the Court of Appeal of Bermuda have in fact stated that the appropriate route in circumstances facing the appellant is an application to reopen, and are intending to deal with an application to reopen, pending your lordship's determination. That leaves, I think, on this point, just the point that's made about Berry number 2. I think my short answer in respect of Berry number 2 is it is a very different case, and it is clearly distinguishable from the present circumstances. I mean, the Court of Appeal in Berry number 2 themselves described it as a rather, quote unquote, rather extraordinary case. You've got the authority, the supplemental bundle at page 24. And sorry, at page 24, you will see that just before the last substantive paragraph, for the background to this rather extraordinary case, is how it's described by Lord Justice Watkins. Your Lordships have the facts of Berry.
So just so I'm clear in my mind, this was an open appeal, in effect. Is that right?
No. So it was no. By the time it got back to the Court of Appeal, it was a closed appeal in the sense that. So Mr. Berry is convicted of a drugs offence at first instance. He appeals on. Sorry.
Explosive device.
Oh, sorry. My learned friend is quite right. And explosive devices. It's actually a very, very different offence. There are four grounds of appeal run in the Court of Appeal. The first ground of appeal is about the construction that the judge placed on the statutory provision that led to the conviction. And the Court of Appeal here, I think it is said, recorded by the Court of Appeal here, they hear argument on all four grounds, but they only give a reasoned determination on the first ground, and they find that the judge misconstrued the statutory provision, therefore misdirected the jury, and therefore they quashed the conviction. The Crown has a certified question that goes up to the House of Lords on this question of statutory construction. And the House of Lords find in favour of the Crown, and they reinstate the conviction. And there is no suggestion made by the defendant that the House of Lords should deal with grounds 2 to 4 that haven't been dealt with by the Court of Appeal. And that is important in the reasoning of the Court of Appeal, because they analyse whether there was actually the power of the House of Lords to step outside the certified question, and they find that there clearly was. And in those...
Or the House of Lords could have remitted it on those points.
Exactly.
That was the problem, they didn't.
No, yeah. And
Probably because it was overlooked, I suppose.
Yes.
for whatever reason, those grounds 2 to 4 are not addressed by Court of Appeal or House of Lords. And then when the conviction is reinstated, my learned friend is instructed and makes an application to reinstate the appeal in the Court of Appeal for a reasoned determination on grounds 2 to 4. And the Court of Appeal, Lord Justice Watkins, says effectively, it's page 28, once an appeal reaches the House of Lords, we take the view that a party to the appeal has had a final opportunity within the appellate system laid down in the Criminal Appeal Act 1968 to bring such points as he wishes to make to the notice of the House. And I think what my learned friend says is, in the appellant's original criminal appeal, he has appealed to the Court of Appeal unsuccessfully, then applied for permission to the Privy Council unsuccessfully. Applying the principle in Berry number 2, there has to be a real question mark whether he can now make an application to the Court of Appeal to reopen his appeal. And I say Berry number 2 should be confined to its very specific facts that concerned sort of extant arguments not being considered in a live appeal, rather than the situation that we are dealing with, which is a sort of an entirely new argument that has not been advanced before the Court of Appeal or the Privy Council.
Otherwise, it would depend on the happenstance as whether a person had tried to get permission to appeal to the Privy Council or they hadn't, and it couldn't be relevant.
My Lord, I, with respect, I agree, but just also looking at the sort of jurisprudence that the Court of Appeal, because this is a case from determined in 1991, and as I've just made this point, that the reopening jurisdiction has developed fairly substantially since then, because if you look at Berry number 2, the discussion at the bottom of page 26, there is a discussion about the cases such as Majeski and Daniel, where they're talking about extensions, refusing extensions of the time, reopening if there has been a nullity. And they say at the top of page 27, there is, in our view, no warrant for regarding what happened on appeal in the present case as a nullity, nor was the court misinformed. So they're obviously looking at it from that rather narrow perspective of the jurisdiction to reopen. But following cases of Majeski and Daniel, you then have Yassain, and you have cases of Zuman, where the Court of Appeal has made it clear that the reopening jurisdiction is not confined to procedural errors or nullities. So I say, first of all, facts are very different and can be distinguished on that basis alone. But if necessary, I do say, insofar as that played a part in the Court of Appeal's reasoning in Berry number 2, I say that the law has moved on, such that in these circumstances there would be jurisdiction, obviously, to reopen. That's what I say about the Berry number 2 point. And I think the final point.
But I mean, anyway, we've got Roberts that says there is.
I thought, yes, I do make that point, but I can see the argument that this point was never raised in Roberts, and had it been, the Court of Appeal might have said, well, actually, we haven't actually got the jurisdiction. But no, the Court of Appeal certainly are treating themselves as having the jurisdiction to determine an application to reopen in these circumstances, and they're obviously aware.
We don't know in Roberts whether there have been previous attempts to appeal to the Privy Council.
I was just thinking that, and there weren't, my lord. So I think, in fairness, the Court of Appeal, they wouldn't have had in mind whether the appellants before them had gone to a tertiary court or not.
Right.
And then, really, the final point on adequacy really goes to the Roberts point, and I will address this when I'm addressing grounds 2 and 3. But just in short, we say that the appellant can't rely simply on his disagreement with the outcome in Roberts to transform what we say is a constitutionally adequate remedy into an inadequate one. His complaint really lies with the legal test adopted rather than the remedy itself. We do obviously, though, say, for the reasons we address under grounds 2 and 3, that the Court of Appeal's approach in Roberts was both principled and correct. And I think I've taken you to paragraph 56 already of the Court of Appeal's judgment, where they make the point about adequacy of redress, and they say it's not necessary to show that if you avail yourself of the means of redress, you're bound to obtain it. It's enough to show that you can obtain a remedy if you're entitled to it. And I say, with respect, that is the right approach to this question of adequacy. Lords, that's...
But if the substantive test in Roberts was too narrow to address the constitutional concerns, I mean, it seems to me it would follow that it was inadequate. So doesn't it mean that we have to address the test in Roberts to see whether it...
I think if you're not with me on my first question that I say needs to be asked on section 15.2, namely, were there adequate means of redress, which I say is case dispositive. If we're in the realms of looking at whether the reopening jurisdiction are adequate means of redress, I think you do have to engage with whether the test in Roberts is too narrow. But that's why I do say...
well, if we thought it was too narrow, it would be a bit unfortunate if we just let it go by on the basis that you had a knockout blow.
I don't see how you do have a knockout blow if the test is inadequate.
Because it wasn't raised at the trial.
Because, my lord, it wasn't, yes. And I do say that because of the very clear wording of section 15.2, the board would in fact be precluded from granting constitutional redress in those circumstances. Which is why I started with that point, that you only get to the adequacy of or the appropriateness of the test in Roberts if I'm wrong that somehow this appellant did not have adequate means of redress at his trial, and I just say that is an unarguable point with respect, because it is only met by the waiver point, and I say that's not an answer.
But that would let in the most outrageous cases. There would always be an adequate... Sorry, you couldn't get any relief subsequently by applying to the Court of Appeal to reopen a case because you could have raised the issue at the initial trial. It doesn't matter how bad the constitutional breach was or how fundamentally it affected your rights or how little it affected the rights of the public, you would be precluded from doing so.
My Lord, if you had...
I don't think you're saying it's an answer to the right to reopen, are you? You're saying it's an answer to the constitutional motion.
Yes. Yes. No, absolutely. Sorry.
You're saying in the constitutional motion there's a short answer, which is that the point wasn't raised at the trial.
Yes.
But he still has the right in principle to reopen. However, if we thought that the test for that was wrong, it would be a bit unfortunate to let it go by without commenting on that, even if we don't have to.
Yes, I suppose yes. It could be said. It could be said it would be, but at the same time, properly analysed.
You say we don't get that.
You don't.
Because the whole thing's an abuse of process anyway, yes. So should we just chuck it out?
Yes. And I say, the Court of Appeal have made it plain that they are going to determine the application to reopen.
Yeah.
But no, I don't. But yes.
However, if we think it would be determined on the wrong basis, it wouldn't seem very desirable just to keep quiet about that.
Because in fact the Court of Appeal didn't rely on your section 15.2 point.
No, you're quite right, my Lord. They said there's adequate means of redress because it is a reopening application.
Yeah. I'm not saying I'm not saying you're disqualified from raising your section 15.2.
No.
The fact is that the appeal is against a decision which didn't turn on that.
No. But I say the board is obviously able to make a determination on whether or not there were adequate means of redress at the original trial. Or
so was that argued in the Court of Appeal? I'm not sure.
Your knockout point.
Your knockout.
I don't. Well, I can certainly ask. I suspect, given that it's not given that it's not addressed.
Seems unlikely.
Given that it's not addressed. I think, and I will need to check. I think there is reference made to the fact that this is a point that could have been taken at any time, but it's not. That is not said
to mean that there was an effective remedy. Otherwise, they wouldn't have gone through the hoops of saying that you've got the right to reopen, and that's the effective remedy.
Yeah. No, I accept that, my Lord. But as I say, if I'm right, then I do say that is a complete answer to the appeal. I take my Lord Legate's point that if you were to form a view that the test in Roberts is an inappropriate test, then it would be unfortunate if that was then allowed to be applied to the appellant's application. But I suppose the remedy for that is that...
come back here.
Yeah.
If there's a right of appeal.
Yes.
Yeah.
Right.
But again, I can see perhaps that Melinfran's argument may be a lot stronger if this is an appeal from Trinidad, for example, where the constitutional provision is a discretion. But the constitutional provision we're dealing with in 15.2 is very clear. It precludes the granting of constitutional relief.
However, as Lord Sales pointed out, we've got a decision at the moment of the Court of Appeal saying that the right to reopen, as characterised in Roberts, is adequate.
Yes.
Is effective, and so we almost have to express our view on that if we disagree with it.
And I'm more than happy. Obviously, I'm now coming on to really deal with that aspect of the appeal, and I don't want the board to think I'm focusing unnecessarily on the first part because I think I'm in trouble on the second. And in fact, if you read our written case, it's fair to say that it really goes to this question of whether Roberts is the right test and whether reopening is adequate.
Yeah. I mean, you're saying don't lose sight of the constitutional architecture. That's
Yes.
section
Yes.
15.2 point.
Yes,
which
my Lord, indeed.
we'll have to consider. But then you say, and the Court of Appeal was right for the reasons it gave.
Yes.
Fair.
Yes, exactly. So ground one is this, if I can call it the retrospectivity ground. We deal with it at paragraphs 59 to 113 of our written case. That's starting at 275. Putting it bluntly, we say that the appellant's case rests on the sort of flawed premise that a declaration of constitutional invalidity necessarily carries with it automatic and unlimited retrospective effect. And we say that is not the law in Bermuda, nor is that the law of any of the comparative jurisdictions relied upon. And the appellant's complaint is really that the Court of Appeal erred by holding that the decision in Roberts was of general application. So in other words, in holding that declarations of the courts finding a law to be unconstitutional did not ordinarily have retrospective effect. And I say, well, that is not what the Court of Appeal actually held in Roberts. Roberts was dealing with the consequences that the declaration made in Trott had in 3 closed cases. The Court of Appeal in Roberts did not hold that declarations of the courts holding a law to be unconstitutional did not ordinarily have retrospective effect. They held that where you're dealing with closed cases, the declaration in Trott, without more, did not compel the reopening of final convictions. And we say when one looks at cases like Cadder, which I'll take the board to, there is nothing at all controversial with that finding.
Well, I think the appellant has to accept that in principle, because he doesn't say that automatically all convictions are invalidated.
Well, and it may be that I'm sort of addressing a point that I don't need to labour, but the reason I do so is because it is, and it's quite important, I think, in Bermuda, because what is being said by the appellant, certainly fairly forcefully in writing, is that the reliance of the Court of Appeal on Arbor Hill was just completely wrong. The Court of Appeal, I think he said, well, the Court of Appeal shouldn't have even been looking at Arbor Hill because it's an Irish case and it's a different constitution. And there seems to be the Court of Appeal in Bermuda seem to have thought there may be something in that argument, because they refer, when giving leave to appeal to the board, they refer to the Arbor Hill decision and the fact that Bermuda is a completely different, has different constitutional provisions. And I'm told that certainly practitioners in Bermuda would be interested to understand what the board makes of that argument, whether it was wrong for the Court of Appeal to even refer to Arbor Hill. But I mean, my answer on Arbor Hill is the Court of Appeal don't slavishly look at Arbor Hill and say, well, that's the answer. They say, well, this is persuasive authority. We acknowledge that this is dealing with different constitutional provisions and it's a different constitution, but the judgment, very detailed judgment, and going through a lot of comparative jurisdictions of the Chief Justice in Arbor Hill, they say is highly persuasive authority that they then apply. But it's not just Arbor Hill. As I say, it's...
Well, also, if I may say so, it doesn't seem to me that it's an authority which is completely against retrospective effect, because the starting position for us is that Section 519(2) is unconstitutional. Wasn't appreciated at the time, but the case has to be approached on the basis that that unconstitutionality is relevant to what happened in the trial here. The question then is, what should happen now, having regard to that fact?
Yes, my lord. With respect, I entirely agree with that, and that may be what Mullane Friend's case is now. But certainly, the written case and the arguments that we respond to in our written case puts it higher than that, and takes real issue with reliance on Arbor Hill. And as we point out in our written case, it's not just Arbor Hill, it's cases such as Cadder as well that make this point, because there is effectively, what is said in Arbor Hill is that there's a carve-out from this principle of retrospective effect in cases of closed or in closed cases, in
I
cases
think
where
the
you've got
point
final
that
convictions.
My Lord Sales was making is it's not really a carve-out of retrospective. It is, the Constitution says this provision is unlawful, that is, it's unlawful from the date it was passed. What do we do about it now? That's the question.
Yes.
And so it's, there clearly is a retrospective unconstitutionality of the provision. And the only question is then, what do we do about it?
Yes. Yes, and I think perhaps it's rather not terribly apposite to refer to it as a carve-out, and I would accept that. But I think the question is, well, as you say, what do we do about it? And that was what the Court of Appeal were engaging with in Roberts.
Is that the method applied in CADA or not? That is a recognition that it was always it was always unlawful, or do they use the word retrospective effect in relation to the remedy?
Well, it was probably easier to answer that question rather than I was going to come to CADA, but I can take it out of turn. CADA is at 547. And it's really, I think, 573. So we're in Lord Hope's judgment. It's para 58, I think,
Just give me the page again.
573, my lord. So 58, the now considerable number of dicta to the effect that the court has a general inherent power to limit the retrospective effect of its decisions, and refers to Spectrum Plus, and also the principle of legal certainty in Merckx and Belgium. These are all referred to in our case. Just pausing there, I suppose, that is perhaps worthy of note of itself, because the Court of Appeal make this point, but the reasoning applies equally in Bermuda, because the principle of legal certainty is in fact inherent in, as Merckx makes clear, the European Convention, and the European Convention applies to Bermuda by virtue of a declaration of the UK under Article 63. So that is, I don't think there's no issue that the principle of certain finality applies, but that's just.
I think you probably get to the importance of the principle of legal certainty just from the Bermudan Constitution itself.
I agree with respect, my lord, entirely. But just for the avoidance of doubt, as we were looking at Merckx and Belgium, I just thought it was, your lordships, I'm sure, know this already, but the European Convention applies by way of a declaration of the UK to Bermuda. And then back to Lord Hope at bottom page 573, para 60. That is not to say that the principle of legal certainty has no application. On the contrary, I think there are strong grounds for ruling today on the basis of this principle, and bearing in mind the fact that in Salders, objection could have been raised at any time after the right of challenge on convention grounds became available, that the decision in this case does not permit the reopening of closed cases. Cases which have not yet gone to trial, cases where the trial is still in progress, and appeals, but have not yet been concluded, will have to be dealt with on the basis that the person who is detained must have access to an enrolled solicitor. As for the rest, I would apply Chief Justice Murray's dictum that the retrospective effect of a judicial decision is excluded from cases that have been finally determined, and reference to Arbor Hill, and then sets out, para 61, some of the paragraphs from the Chief Justice's decision in Arbor Hill, and then picking up again from Lord Hope. In para 127, he observed that the applicant, like other persons, could have sought to prohibit prosecution on several grounds. Not having done so, they were tried, neither convicted or acquitted under due process. Once finality is reached in these circumstances, he said the general principles should apply. So we do say in respect, it's not just Arbor Hill, but it is CADA and also Marx and Belgium that don't support the assertion that retrospective relief is required not only in every case, but in cases, closed cases such as the present. And it,
I mean, in effect, it seems to come to this, that the balance of the equities, if that's the right way to describe it, is changed, where, as between when you have an open case, including going up on appeal, and when you have a closed case where the appeal is shut down. And it seems that in looking at the balance of the equities, where you have to take account of the public interest, the interests of the victim and the witnesses, as well as the interest of the defendant, a factor which is relevant to bear in mind is, was there in fact an opportunity for the defendant to have raised the matter as the things were going forward?
yes. Yes. And it may be just having looked at Arbor Hill and CADA and Merckx, that is, I need to say no more really about retrospectivity.
Insofar as the Arbor Hill, I think, recognises an exception, it's in very sort of even narrower language, if you like, than the Roberts, the one discussed for reopening generally, although wholly exceptional as opposed to exceptional. And it wouldn't really make sense for it to be narrower than the general approach, would it?
No. And I say, I mean, the Court of Appeal in Roberts, you have no other effective remedy, exceptional circumstances and substantial
And that's the appropriate
injustice.
test.
That's the
here as
appropriate
well.
test, yes. I mean, there are points taken that I might just leave in writing but flag them. I mean, there's a point taken on Section 2 of the Colonial Laws Validity Act. And I think it is said against the Court of Appeal, well, you didn't take into account the history and the context of the Bermudan Constitution. And we deal with this in our written case. I say that doesn't take the argument any further forward. And so you have what I say in writing on that. We deal with Spectrum, the Westminster Bank and Spectrum, and HM Treasury and UPMED cases, because it is said, in fact, the Court of Appeal failed to have sufficient regard to the approach taken in the UK courts. Well, actually, when one reads Roberts, the Court of Appeal cite a number of authorities from this jurisdiction. They specifically cite National Westminster Bank and Spectrum and the UPMED case. They cite CADA, and they obviously cite Arbor Hill and Merckx. There's a point taken about Selassie and the Queen, which is I think it said the Court of Appeal failed to have regard to that specific decision, or at least they didn't derive the right principles from it. You have Selassie at page 1203. I don't propose to ask the board to turn it up. It concerned a very, very different situation. It wasn't dealing, it was an open criminal appeal for a start. It wasn't dealing with retrospectivity in respect of closed cases. And with respect to the Court of Appeal, they deal with it in their judgment, and they explain why it doesn't help them determine the issue that was at the heart of the Roberts case. So I say that doesn't take the argument any further forward. And finally, and I think this probably potentially leads on to what I have to say then about grounds 2 and 3, because the appellant says, well, the Court of Appeal in fact erred because it failed to take into account the rights that were at stake. And we address this, it's paras 99 to 106 of our case, starting at page 285. And three short points. First, obviously impartiality is a central component to the right of a fair trial, but it does not follow that every finding of historic impartiality compels automatic invalidation of a conviction. I think this goes really to the heart of the appellant's submission, and there's a case that you haven't, it's cited by us in our case, but the board hasn't yet seen it. It's a case of Ballinger, which is at page 590. It's a Court of Appeal decision from this jurisdiction. It was dealing with an application to extend time to appeal out of time. I say really on all fours with an application to the jurisdiction to reopen an appeal. Mr. Ballinger had been convicted of an indecent assault at a court-martial. He was a serving naval officer, and a serving naval officer was the judge advocate. And after it had been held that court-martial, where the judge advocate was a serving naval officer, did not comply with the requirement under Article 6 for an independent and impartial tribunal, Mr. Ballinger applied for an extension of time for permission to appeal his conviction. I think the extension of time needed was about 1 year and 3 months. And he submitted that his trial had been unfair and in breach of Article 6, and therefore his conviction was unsafe. And in the circumstances, he said the court obviously had the discretion to grant an extension of time and should do so. And the respondent in that case, the Crown, submitted, well, it's not enough for an applicant to simply show there's been a breach of Article 6 and that your conviction is unsafe. You have to demonstrate, in addition, a substantial injury or injustice. And if we pick it up at paragraph 22, page 595, the Lord Justice Scott Baker says, in our judgment, there is nothing incompatible with the Convention in the imposition of time limits, provided they are not too short or rigorously enforced. For every criminal appellate system to operate efficiently, there has to be a time limit specifying the period within which the conviction or sentence must ordinarily be challenged. Broadly speaking, the longer the delay, the more compelling the reason. Sometimes considerable delay and extension time is granted. Not in position here. A line has to be drawn somewhere. Even after the decision in Dundon, when the law was clarified, there was further delay. As Mr. Havers put it, anyone who seeks further 3 months in such circumstances takes a calculated risk. And then conclusion, 5-6 lines up from the bottom. In our judgment, an applicant seeking extension of time for leave to appeal in circumstances such as those in the present case has to show more than there has been a breach of Article 6, and that in consequence his conviction is unsafe. He must also show he has suffered a substantial injury or injustice. This the applicant has manifestly failed to do, and accordingly we refuse to grant an extension of time. In my submission, the reasoning in Ballinger reflects the same balancing approach that's adopted by the Court of Appeal in Roberts. You can't simply say, well, there's an appearance of bias in a closed case. In a closed case, you have to go further and you have to establish substantial injustice.
But just on that, I mean, suppose the judge advocate was shown to be actually biased.
Yes.
Would that not qualify as someone having suffered a substantial injury or injustice where they'd gone down to trial and been convicted by someone actually biased against them?
I think, my lord, it probably would. That would probably satisfy the substantial injustice.
Right, even though one couldn't tell whether, if they'd been tried before someone that wasn't biased, they would have been convicted or not. The reason that I'm pressing on this is I hope we're going to come back to paragraph 120 of Roberts, where two things are said to be in place to demonstrate substantial injustice.
Yes,
I'm wondering whether it's necessary to have the second. That's why I'm asking you these questions.
Yes, no, I appreciate that, my lord. I think, I would say.
So, I mean,
the second is impossible to satisfy, isn't it? You can never possibly show that a different jury would have probably have come to a different result.
No.
It's really like saying there's no right to reopen at all in these cases.
No, I think
or as I would like to put it, if you've actually been tried by someone that's actually biased against you, that in itself is a substantial injustice.
Yeah.
I would accept that.
So well, perhaps can we ask you to address then paragraph 120, page 496 in Roberts? Because if we're going to say something about the Roberts S. If we're unhappy with that, we'd better have your submission on that. So they start off in quite general terms at paragraph 69, page 481, where they refer to the accused suffer substantial injustice. That sort of is a rather compendious expression. It's
Yes.
really in 120 where they seem to spell that out, what that means here.
I think I would accept if there were circumstances that give rise to sort of actual bias. So if you have a situation where you were able to show a pattern, for example, of the Crown sort of excluding.
If you could show that they deliberately tried to get a jury that was going to be
Yes.
partial to the Crown, or that
Yes,
would seem to be a substantial injustice.
I would accept that, my lord.
Yes, thank you very much. That's what I wanted to raise with you.
So it's both of those things. It's both actual bias and bad faith in jury selection.
Yes,
Bad faith in the sense of manipulating the jury selection to obtain a jury that isn't fair, independent.
yes, because I think yes, that has to follow. Yes,
I mean, insofar as you're talking about the prosecution, that's
Obviously,
as
yes,
far as
yeah.
they could go, because
Yes.
the prosecution isn't going to be the judge. But
Yeah.
I mean, presumably, if it could be shown that there was a juror who is actually biased, one would think that that was a substantial injustice to
Yes.
be tried by such a person.
yes, yes. Again, yes, I would accept that.
Thank you.
I suppose that would have been a ground of appeal in any event, wouldn't it?
Yeah.
I mean, that doesn't depend in any way on the
No, not
the
unless
selection.
not unless some
process.
new information has come out or something like that.
So it would be enough to show that the Crown had deliberately manipulated the system in order to produce what it thought would be
Yeah.
a sympathetic jury to its case.
Yes.
You wouldn't have to go on and show it was in fact sympathetic, because you could never do that.
I just don't see how you
No, you can't do
could
that.
satisfy that second part of the yes.
But yeah, and again, it seems, speaking with myself, the reasoning would effectively be the same, that if you can see that the jury's been manipulated in that way, it looks like a substantial injustice that you've been tried by such a jury.
Yes.
Even though it would be extremely difficult to go on to try and establish subjectively what each juror.
Well, it would be absolutely impossible because you're not allowed to speak to the jurors even in our jurisdiction. So.
Yeah, unless they pass notes or things like that. Anyway, thank you very much.
And Lord, just sort of finishing off this, but I'd made the Ballinger point, and this is the argument that
So just to go back to this,
Yes.
I mean, if the Crown has manipulated the system in that way, I mean, that again would be a ground of appeal anyway.
yes. Well,
It doesn't
Yes, but
in any way
we're looking to
depend
see.
upon the...
No, but we're looking to see what further than a challenge to the fairness of the trial is needed to reopen it later.
Quite.
And the point is, it has to be something a substantial injustice over and above the fact of having had an unfair trial.
Yes, absolutely. And I say Ballinger is
Yeah.
authority for that, but also Roberts.
But this
Going-
is all in the context of a unconstitutional provision, and it shouldn't be extended wider. So, if in fact there has been a manipulation, manipulating the jury in the choice of the jury, that was a point that could have been taken initially,
Yeah.
and should have been taken initially. It's only when you have an unconstitutional provision that you are seeking to reopen. On the facts of this case.
Yes.
I don't think one goes wider than that. Saying that every introducing further evidence under Ladd against Marshall to establish that the jury were manipulated in the initial trial. I mean, I don't think that arises in this.
No, it doesn't. But again, and this goes back to, and I don't want to labour the first point that I've made to your lordships, but it does go to the adequacy of redress at the trial, because the appellant's affidavit it almost says this in terms that this was a stacked jury and it was deliberately manipulated by the prosecution, and that obviously would give grounds to appeal or make an abuse argument at trial. But
yeah, I mean, it seems to me that would give grounds to appeal even if Section 519 was valid law, because Section 519 doesn't mandate that particular things happen. It just gives the Crown the power to do something.
yes,
But not to abuse it, yes.
yes.
And,
Yes.
and even on Mr. Fitzgerald's case, it's accepted the Crown can exercise its power of objection up to 3. It's, as I understand his case, it's only if they go beyond 3 that a problem arises, even on his approach.
My lord, yes, that is what they say, and I agree, and this is why the discussion we had earlier, when the appellant would not have had to mention the provisions of Section 519(2), because he is in fact saying, well, my jury was stacked against me deliberately by the prosecution. And that is the complaint he makes in his affidavit, and the redress he seeks is a retrial, and that's why I do say, I appreciate I am now labouring the same point, but I do say adequate means of redress were available at his first trial, and that is the answer to this case. I think in grounds 2 and 3, I've said all I need to say on ground 1 I've said all I need to say because we address everything else in writing. Grounds 2 and 3 I largely have said as well in answer to the discussion we've just had, Lord Sales' question about paragraph 120. I think perhaps just one further point. I think it is said in reliance on Taylor and Lawrence that, which is relied on obviously quite heavily by my learned friend, that in cases of judicial impartiality, it automatically renders a conviction unsafe, and that would really justify reopening final cases. Perhaps it's just worth turning up Taylor. It's at 1850 in your...
Sorry, page?
1850 is where the judgment starts, and it's really Lord Wolfe's observation at paragraph 55, which is on 1869. So obviously in Taylor, the Court of Appeal recognises the implicit power to reopen in exceptional circumstances. And one such situation may arise where a decision is alleged to have been invalid due to judicial bias. But the remainder of that paragraph, so this is paragraph 55,
Says 1860.
1869, my lord. I hope I've given you the right reference.
All right, bear with me a moment.
Paragraph 55, and it's about seven lines up from the bottom. What will be of the greatest importance is that it should be clearly established that a significant injustice has probably occurred and that there is no alternative effective remedy. The effect of reopening the appeal on others and the extent to which the complaining party is the author of his own misfortune will also be important considerations. So this is just confirming that, like Ballinger, you need more than a complaint of a lack of partiality. You need to show substantial injustice.
Yeah, and he's talking about showing that a significant injustice has probably occurred, but that would fit with, if it's a significant injustice that there's been actual bias or manipulation of the jury to produce a skewed thing, that's covered by this formula.
Yes.
And indeed, he's contemplating a case of bias as such a case. It's quite helpful in that point.
And I think he's not saying you've got to show that it would have been a different result.
No. And and then finally, really, the point that the test is impossible to meet. Well, the test isn't, with respect, impossible to meet. It's a high threshold, but it's a necessarily high threshold because of the interest of finality in criminal matters, and we're dealing with closed cases. So, my Lord, no, my Lord, just a point of correction. I think in Roberts I said none of the defendants had been to the Privy Council. I think and I recall now, it's right, Mr. Brangman had gone to the Privy Council. So I was wrong to say that the Court of Appeal, when they were considering those three reopening applications, did not know that there'd been a tertiary decision.
But the point was.
Absolutely.
The
the Berry point was not raised. No.
And when you say he went to the Privy Council, had he had a full appeal?
Yes.
Yeah. I think the board.
It wasn't just an application for permission, which.
Oh, I
was
see what you mean.
refused.
A full appeal to the council, you mean?
Yes.
Yeah, yes, I can give it. So it's 2015 UKPC 40. It was all to do with the admissibility of gang. I now recall. I don't think I was in the case, but
Okay.
yeah. My lords, unless I can be of any.
Could you just
assistance.
go to the test as set out at page 231 in the appellant's bundle? And case, which quotes the Chief Justice at first instance in Roberts. Is that the correct test?
Yes, my lord. Yes.
Yeah, I've got no objection to that test.
No, the only reason I paused is just the.
It's slightly
sort of
differently worded.
yes, I mean, I would say it's slightly shorter. I would say exceptional circumstances, no effective remedy, and substantial injustice.
Yeah.
But I don't think
It's not the wording in Arthur Hill, and it's not the wording in the Court of Appeal in Roberts.
No, I mean, I don't know. I would perhaps condense it, and I would say what the Court of Appeal are effectively saying is the test that is applied in this jurisdiction is the test that they're applying. So I would rely on, as they say, it's the test set out in Gohill in the Court of Appeal. So it's exceptional circumstances, no effective remedy, and substantial injustice.
And indeed, it's now in England in the criminal procedure
Rules,
which I think are in your
36. I think
separate second bundle. The first attempt produced the civil procedure rule.
I did wonder why I was talking about part 35
Yes,
offers, but I thought I'd completely misunderstood what this appeal was about. But no, it's Rule 35 of the criminal procedure rules. 36. Well, unless I can be of any further assistance, those are my.
Yes, thank you, Mr. Gould. Anything to say? Thank you. Mr. Fitzgerald.
My Lord, so just picking up on the very helpful interventions by my Lords, we do submit that the test, as enunciated in Roberts, is too high, and that if the test is too high, one matter has been identified, which my learned friend concedes, that's to say the requirement of causation at paragraph, I think it's 120 and then again 191, then there was no adequate means of redress at that time, that he continued to pursue his remedy after Roberts on constitutional relief. And my Lord, so that we do make that point, and in any event, as the court has indicated.
Sorry, but why is that the case? I mean, he could have raised it and then come to the board saying this is wrong.
Well, my Lord, if the only remedy available is, well, we don't know whether that's the real question, my Lord. It's
right. But you started your submission by saying if this test is wrong, he had no adequate means of redress. I'm just saying. Yes. You could have come to the board and said this test is wrong.
Well, my Lord, if there's an appeal to the, supposing he goes and he reopens, and in fact he tries to reopen and he's told you can't reopen because you haven't even begun to show lack of causation.
Right.
So then the question is whether there's actually any appeal to the board from that.
Right.
And my lord, there's been a reference.
Mr. Poole says that there is.
Well, I have to say, my lord, we've never heard about these rules, and when we looked at the rules that were referred to, they refer to the normal rules for appeals and extension of time, not to. There is no specific rule which even mentions the reopening jurisdiction.
Right.
And my lord, since we've only heard this for the first time this morning, I do ask that my lords give us the opportunity to comment on such rules as have been provided, because having seen what is purportedly relied on, it doesn't appear to make any mention of a reopening jurisdiction. It's about the normal leave to appeal from a substantive conviction and extension of time.
Well, take extension of time. Suppose you had an application to extend time
Yes.
to bring an appeal, which was refused by the Court of Appeal.
Yes.
Would the individual have the ability to apply to the board to appeal against that decision?
I think there is a Privy Council decision on this very issue from St Vincent.
Right.
And they argue that there was no jurisdiction because it was a death penalty case. The Privy Council said that there was jurisdiction to hear.
The Privy Council said there was jurisdiction.
Yes, because
I have to say, I would think there would be jurisdiction.
Yes.
It might be difficult to get
Yes,
leave, but
I mean, it would depend on, of course, the House of Lords decided in the late 19th century in Lane and Esdale that there was no such appeal to the House of Lords from the Court of Appeal.
Yes.
But of course it depends on the constitutional arrangement of the individual territory.
It required some fancy footwork, if I can put it that way, but we can provide again that.
right. Anyway,
But
in
my
so
lord,
far
this
as you're
whole-
making this submission, it seems to depend on whether there would be the possibility of a right of appeal. In this way
Yes,
through to the board.
it is important, my lord, whether there is an avenue of appeal and whether there's a recognised way of getting before a court. And we say in both those respects, there is sufficient uncertainty that we submit that there is not an adequate alternative remedy.
The anterior question was that there is no possibility of constitutional relief in circumstances where you could have raised this before either the trial judge or in the Court of Appeal. So in circumstances whereas here the allegation is the jury was stacked against you, that could have been raised. That falls within 15(2) of the Constitution. It's a remedy that was available, has been available, and wasn't used, and that prevents constitutional
Yes.
being granted. What do you say about that?
Well, my lord, I say that the new point that's introduced after the decision in the Trott case is the recognition of unconstitutionality of the more than free challenges, and that recognition does give rise to a legitimate ground of challenge which we couldn't avail ourselves of at the time. Well, sorry, the appellant couldn't avail him. The appellant could not avail himself of that at the time.
Why not?
Well, my lord, because the unconstitutionality had not been recognised.
I mean, it may not be recognised, but it could have been. It could have been raised.
Well, then we really are back in. As I know I framed it in the waiver thing, but I do say that it's a useful language that is used by I think it was by Lord Bingham in the Miller case. That's to say, is it something that you would know about?
Which page...
That's the waiver point, though, isn't it?
Well, it's the two shade into... Because before you can say, look, you had an adequate means of I think you've got to know about it. It's like saying, you know, you had a right of appeal, nobody knows about it. I mean, the fact it's in some book which you can't have access to wouldn't mean you had adequate means of... I'm just trying to give an extreme example. So I do respectfully submit that it is relevant whether this would be something that a prisoner or a defendant would be aware of, or indeed his lawyers would be aware of.
But this appellant indicated in his evidence that he had a very strong grievance about what had occurred.
Yeah, well, but not this precise grievance about the excess. His grievance was about he thought that they were stacking the jury. I accept.
There's always a potential ground of appeal, I would have thought.
Yes. Well, my lord.
He's likely sort of hoist with his own petard and that. I mean.
Well, my lord, all I can submit is that, and I think it's really the point that my Lord Stevens made. Once you're in a recognised unconstitutionality of section 519(2), you're in a new realm, a new ballpark, or whatever one wants to domain. Well, sorry, once you've got a recognised unconstitutionality and your complaint, you then see what remedy you have.
But just in terms of whether you get assistance from Miller, surely my lord is right that the observations in Miller are directed to the question of whether there was a waiver of rights there. And obviously, if you're going to waive rights, it's a very high test for that, which requires actual knowledge of your rights and so on. It doesn't follow from the observations in Miller directed to that question that it's necessarily going to be the same approach if you're addressing a different question, which we are.
Well, my lord, I would just submit that the prohibitions in the Constitution are meant to be, using the European phrase, practical and effective and comprehensible. I mean, it's pretty difficult to say you had adequate means of redress if you weren't aware of the particular unconstitutional...
He certainly had adequate means of redress in relation to a stacked jury.
Yes.
And
I'd accept that.
Yeah.
I'd have to accept.
And therefore, that is the reason why he doesn't bring that. I mean, the case is being run not on the basis of a stacked jury, but a jury which has the appearance of bias,
Yes.
rather than one that was actually biased.
My lord.
And
Yes.
and there was no appeal, was there, in relation to the stacking of the jury?
No.
Are there grounds of appeal in the bundle? The initial grounds of appeal?
I think they are, my lord. You mean the ones where when it went up the first time?
Yeah.
No, my lord.
His outrage didn't follow through to having a ground of appeal in relation to stacking the jury.
My lord, no, that's right. My learned friend referred to Taylor and Lawrence. It's at tab 54, it's page 1869, paragraphs 55 and 58. Just to draw attention to the fact that at paragraph 58, that's at 1869, I think it is, they refer to the fact that the bias was that of the original court at first instance. So that is being contemplated. And Taylor and Lawrence, as the court's just been shown by my learned friend, refers to the fact that bias can be a reason. It would also appear that it's contemplating quite clearly in those passages apparent bias as enough in Taylor and Lawrence to reopen a case. So we do rely on that. And of course then Yassine, which my learned friend also took you to, imports the...
Where does Taylor and Lawrence deal with a reopening of a closed case on the basis of apparent bias? Which passage?
55, was it?
55, my lord, yes. So tab...
It was page...
So 1869, my lord. So 1869 in Taylor and Lawrence. Your Lordship will see one situation at 55.
Sorry, wait, could you just give the page?
It's page 1869, para 55.
Yes.
If bias is established as being a breach of natural justice, it makes it imperative that it should be a remedy. The need for effective remedy in such a case may just in taking the exceptional course of reopening proceedings, significant justice. And then can I just make the point that at H, paragraph 58 at the bottom, the bias which is alleged here is in the court of first instance, not the appellate court. That's to say it's not a sort of Pinochet type case, but it's where the bias, there's new evidence. And there had already been a rejection of the bias case and then more evidence of bias. And then it refers to...
Look, I mean, at paragraph 55, Wolf is making the point that when you're trying to balance the, I used the word the equities before,
Yes.
It's a relevant consideration, the extent to which someone had an opportunity to raise the relevant matter in the course of the proceedings.
Yes, what do you mean author of his own misfortune?
Yes.
Yes, my Lord. Well, I
And there's also a significant injustice.
Yes. Well,
No alternative effective remedy.
my Lords, you have our submissions that this would be, apparent bias would be something of fundamental importance, in the words of Lord Hope, in the Miller case, so that would be sufficient. Then, I'm just, if I can just, my learned friend referred to Ramanoop and the existence of a parallel remedy. My Lords, in that case there was talk of conversion, not in the spiritual sense, but in the sense of changing the nature of the proceedings from constitutional to writ proceedings. And just to deal with Farrington on that issue too, at paragraph 1, it's referred to the fact that there is, before the court, an application to reopen, but at paragraph 3 at page 402 of Farrington, it's clear that was, as it were, a change that took place during the course of the hearing. There are parallels with this case where we're saying, when we have been saying since the case was settled, that in any event, the board can convert this into an application to reopen.
Sorry, what are you getting from paragraph 3 on page 400?
Okay, my Lord, paragraph 3, page... Yes, it's that things changed during the course of the hearing, page 402. That's to say, it wasn't formulated originally as an application to reopen, but then in relation to the procedural route, this is paragraph 7, the Attorney General submitted an application could and should have been made by the appellant directly to the board to rescind or vary its advice, submitted that there was no requirement for the appellant to bring in any new constitutional proceedings. On behalf of the appellant, Mr. Cliff Mouse accepted an application could have been made directly to the board, and she made that application. Well, your Lordship will recall.
No, I think your recollection is...
Well, I'm helped by my friend, Miss Cliff Matthews, is here, and she tells me that's what happened. So, I mean, if you are able to make it...
That doesn't sound like converting the Constitution. It sounds like a new application.
Yes. Okay, well, whatever it... Sorry, man, I'm not being flippant, but whatever is the correct characterisation of what we are seeking to do, we are saying to the court, there's not much point in going down to the Court of Appeal, from which there may or may not be an appeal up to the board, if the board can say, well, if your complaint of apparent bias is made out, you can have leave to reopen, and we'll leave the Court of Appeal to resolve the issues of fact. So that's why we have invited in our case and in our submissions that the board taking that course. At least that means that there is there is a clear path to reopening, rather than take your chances. The form that has been referred to is...
Sorry, the Farrington case can be summarised as follows. It was a constitutional appeal.
Yes.
It was going to hit the rocks on 15-2.
Yes.
And seeing that, we acceded to an application to deal with it under the Pinochet jurisdiction.
Yes, yes.
And so it wasn't a conversion. It was an application being made to us in circumstances in that case where the outcome was almost agreed of that application.
No, I do accept that. Then the board has our points on the reopening. We've submitted that it isn't clear that there is a form in relation to an application to reopen, or a form in relation to renewing an application to reopen. The forms that we have been shown over the lunch break appear to relate to a normal application for leave to appeal or for extension of time. It's not clear that whether there's a right of appeal from a refusal.
Just, can I have a think about that in a moment?
Yes.
That is, if there is subsequent evidence in a closed case that you want to bring to the attention of the Court of Appeal, new DNA evidence which exonerates the accused, then presumably put in an application for an extension of time.
No, my lord.
What do you do?
Can I try and deal with that?
Yes.
Subsequent developments of that sort would be dealt with here by the CCRC,
I know.
and there by an application to the governor, who has the
Extension
same
of time
power.
comes if you haven't had a first appeal.
Sorry?
The extension of time is relevant if you haven't appealed in the first place.
Yes, that's absolutely right, my lord. But this is quite important, that there is a jurisdiction for the governor in the case of a new evidential development, for the governor to exercise the power that used to be exercised by the Home Secretary in England under Section 17 of the Criminal Appeal Act, and refer the matter back to the Court of Appeal. That jurisdiction is exercised in the Caribbean. It's subject to judicial review if it's refused, but it's a jurisdiction that is typically appropriate where there's some, the kind of situation that my lordship, my lord refers to. The problem of it is that it's the executive and then judicial review of the executive, so it's cumbersome. My lord, if it is appropriate to seek to reopen in those circumstances, it would be extremely helpful to know that, because
I would have thought that on an application to reopen, obviously one factor will be how serious the unfairness has to be to constitute a substantial injustice. It will also be relevant for the court to inquire or enter into what the reason was, if it was a glaring unfairness, why it wasn't complained about in the first place.
You mean why it wasn't? Yes.
Yes, why it wasn't raised.
Yes, absolutely. Yes, my lord.
I mean, that would be one aspect.
Yes, yes. I'd have to accept that. Yes, but my lord, and whilst we're on it, just to tell you what happened in Bury Number 2, because it was left on a sour note. The case
referred back by the Home Secretary.
It was referred back by the Home Secretary and was successful on about 10 points, including that the forensic evidence was completely flawed, that the summing up, which had been described by Lord Roskill in Bury Number 1 as admirable and perfect, was in fact totally unfair.
Was this one of your victories, Mr.
I'm just trying to show my lord that it's not. I'm sorry, I wasn't. I'm just showing that you do need a reopening jurisdiction. You do, or you may need. You may, you know, but I mean, but it is. Again, my lords, I do respectfully submit it's quite important to know what the route is and where the
Well, one route would be to close it down and to say that you could go to the governor and let him sort it out.
Well,
and refer it back to the
Yes.
Court of Appeal if he thought it was appropriate. And,
Yes.
and that,
Yes. Yeah.
that you say is a route that is available. And
Well-
rather than creating a route which would perhaps let in a whole raft of cases that have got nothing to do with constitutional invalidity.
I suppose the problem with that, my lord, is if one looks, I mean, there was a recent case which came up to the board, the case of Maharaj,
Yes.
which was heard by the board, which had gone by the governor route.
Yeah.
It took about 4 years with threats of judicial review before the governor took it. So in that case, it was the president took a decision, then it was judicially reviewed, then it was referred to the Court of Appeal. So
But you can't have every single case where somebody says that, you know, if but only you'd looked at this new evidence,
Yes.
you'd,
Yes.
No. The Court of Appeal would be overwhelmed
No,
with cases.
well, my lord, that's why the reopening jurisdiction appears to be more about where something has gone wrong, such as in this case, where there's something wrong with, like a breach of the rules of natural justice, as opposed to a subsequent evidential development. And that builds on the analogy that it was typically a case where you're saying that there was something that flawed the original criminal process, like bias or a breach of the rules of natural justice. But my lord, that's what we respectfully submit is the distinction. But my lord, it is clear that the actual route that's suggested in Roberts is, in our respectful submission, too narrow, and the test is too high. It is not an available means of redress in our submission. And if I think the formulation that my Lord Sales put to my learned friend, that if the test was too narrow to address the concerns, then there'd be an argument that there were not adequate means of redress, and that we respectfully submit that is the right approach. So, my lords, you have our submissions already in relation to ground one, and my learned friend in relation to ground one said that the principle of legal certainty is extremely important, and that, but in the end, we're not saying that every case must be reopened retrospectively where there's been a finding of unconstitutionality. We're accepting that there is some limit to it, but we say that the notion of fundamental unfairness extends to a case where there's an appearance of bias, and that the error of the Court of Appeal in Roberts, which was repeated in the Court of Appeal in this appellant's case, was simply not to give sufficient respect to the fact of an appearance of bias, and to insist instead on actual bias and causation. Causation seems to have been abandoned now, so to that extent the remedy was inadequate. My learned friend relied on the case of Ballinger, and we just submit that case, that there's no reference there to Miller and to the dicta there about the importance of the appearance of bias, and we submit that that case certainly should not be the guide to the board in this case. And you already have our submissions about the actual bias being inadequate, being too high a test, too high a test, and causation being also too high a test. And it's both at paragraph 120, page 496, and at paragraph 191, at page 509. well, and then the application to consider the matter yourselves, we do make that application. We did make in the case. If the board is prepared to do so, then we would invite the board to consider that. The alternative, of course, is to deal with the reasoning of the Court of Appeal insofar as it's erroneous in applying to, in requiring too high a test, because it was part of their reasoning. And if the board looks at the, it's set out in our case, what the Court of Appeal said in granting leave was, this is set out in our case at page 227, there are some genuinely disputable issues, the existence of which means that we would not refuse the appellant leave to appeal. They include whether or not, given the MUMI is in English statute, the Court of Appeal was right to adopt the approach in Arbor Hill, whether or not certain decisions in relation to rulings about having a retrospective should have led to a different conclusion, and whether the decisions of the House of Lords International, Westminster Bank and Spectrum and other English Court of Appeal decisions should do likewise. Well, of those, we would emphasise that Spectrum Plus, which we've extracted the key aspects of in our case, does indicate a general rule of retrospectivity, but particularly in cases of a fundamental error in a criminal case. And I think we've given you that quotation in the case from, I'm so sorry, if you just, from Spectrum Plus. So you have it there. If I can assist any further, so we...
Thank you, Mr. Fitzgerald. Mr. Poole.
Lord, just one short point to respond to something that, in answer to my Lord Stephen's question, my learned friend said. If there's a closed case in Bermuda where, to use Lord Stephen's example, DNA evidence comes to light that gives ground to appeal, the appropriate procedure would be to apply to appeal out of time. So this is why we've referred
What if you've had the first appeal?
It still would be referred to. This is why I referred to those two criminal forms that, and I made plain when I was making my submissions that they don't on their face refer to reopening applications. They refer to extension of time. And the proof is in the pudding in this case. If you look at page 69 of the supplemental bundle, the appellant has made an application for an extension of time within which to appeal. This is how...
This is the form that it has to be used, because there isn't a tailor-made form.
Yes. And that is the application that the Court of Appeal have engaged with and have said we will deal with pending, obviously, your Lordship's determination.
I suppose, analytically, what you're doing is applying to extend time to allow you to take a new ground of appeal, which you weren't able to take before.
My Lord, yes.
Well, except that your case has been finally determined by the Court of Appeal, so it's not, an extension of time is normally when you haven't exercised the appeal in the first place, and you're trying now to do one very late in the day, but after it's been finally determined, it's not just an extension of time you need, it's to reopen the closed case.
Well, no, you're obviously appealing out of time because you're not within time. But I appreciate.
Well, but that's the problem. I mean, technically you're not, because your appeal has been determined, as my Lord said.
Yes.
But there we go.
Well, my Lord, I with great respect, I find that bizarre. There's an absolute distinction in the English law cases between extension of time where you haven't appealed, because sometimes people haven't appealed but they get a new point, then they apply to extend the time. And if you have appealed, then it's a totally different ballgame. And so, my Lord, that's why we have the CCRC and then in the past the Home Secretary. So,
But the CCRC doesn't exist.
With the governor,
Right.
the governor is the same as the Home Secretary used to be. The CCRC is simply an independent substitute for the Home Secretary. Section 17 of the Criminal Appeal Act in England, and the Governor General's the governor's power is the long stop with new evidence. So, my Lord, we would like to see these forms a bit more carefully and put some submissions in if necessary. Because I mean...
Yes, Mr. Pools, this can be supplied within 7 days.
My Lord, absolutely, my Lord, yes, yes.
And if you need to respond to them in...
Yeah, well, my Lord, if...
Gerald, you can have another 7 days to do that.
I'm very grateful. Thank you, thank you.
Could we also ask if it's possible to get a joint position on the ability to appeal to the board if there's a refusal of leave?
Yeah, you can hear what my Lord is saying.
We had a debate about whether
Yes.
it's jurisdiction to appeal to the board if there's a refusal of leave to extend or reopen an appeal. It would just be helpful for us to know what the technical position is.
I'm sure we can.
In relation to that would be helpful. Thank you very much. We're very grateful, Mr. Fitzgerald, Mr. Pools, for your submissions. We're very grateful to all counsel in the case and those sitting behind you for the preparation of the matter for the hearing today. The board will take time to consider what advice they humbly tendered to His Majesty. Court is now adjourned. Thank you.